My name is Daniel Lipsky. I'm the president of Nationwide Biweekly Administration. I've never done a video like this. It's my first time, so be gracious as I attempt to explain a very devastating event that took place in 2015, and right now it's currently 2019, where the CFPB destroyed me, my family, my company. They teamed up together with two district attorneys who are in California to come after my company, come after me with uh, some false allegations that were uncovered, especially with the district attorneys, where they had outright lied. But the devastation that came from it, a company that had built from one employee to over 160 since roughly the year 2000. And so I put my entire life into it. And so I'm going to read from a timeline chronology that explains how these events conspired together to bring about the destruction of Nationwide Biweekly Administration and myself and my family. In order to understand the situation, we need to start in Ohio in 2010. I'll describe what happened in two stages, as the background involves both the CFPB and their interactions with two small county district attorney offices in California. February 2010, Richard Cordray, then the Ohio Attorney General, entered into an agreed order of voluntary compliance with my company, setting forth all the requirements for NBA going forward in our direct mail marketing letters for our interest minimizer biweekly savings program. They had scrutinized my company for a 2-year period, everything, every bit of calculation, software, scripts, material, processes, every single thing over a 2-year period of time. This program, the Interest Minimizer Biweekly program, is for consumers to easily get automation matched to their paydays, thereby accelerating the principal payments on their mortgage loans, which lowers the interest paid by the consumer to the lender. And again, our program is only for people who lack the self-discipline of making an extra at least 13th monthly payment. Nielsen Research did a survey, found that 88% of consumers do not make a 13th payment on their own. And so the people who call into our company is for those where, we would ask, have you made a 13th payment on your mortgage loan each year just for the past 3 years or 5 years? And almost everybody says no. Even the people who do say yes, which is very few, they still enrolled in our service because they like the automation. And that's the day we live in, is automation, making things easy. We can do everything ourselves if we want to, and that is everybody's choice. Our service is just available for those who want to take a monthly mortgage payment, cut it in half, and have it match their pay schedule, getting paid every 2 weeks. It just makes it easier. And with that schedule, you end up making the equivalent of 26 biweekly debits, which is equivalent to 13 monthly payments. But again, it's you just set the schedule and forget it, and it just comes out every 2 weeks on the same day you get paid. And so again, it's just for the automation and convenience. Anyways, back to Ohio Attorney General Richard Cordray. This agreed order of voluntary compliance, after their 2 years of scrutinizing my company, he approved and agreed to this order. We agreed as well, and the rules going forward were clear. For example, NBA's letter is a comparison of the lender's monthly payment schedule and NBA's biweekly program payment schedule. In Section 2J, the agreed order specifically states what disclaimer regarding the reference to the lender's name must go on the outside of the envelope, stating there's no affiliation, but that the program works for the loan with your specific lender. So a consumer can make a connection, not knowing whether or not, hey, can this work with the loan that I have with this lender. And so it was approved to continue allowing, but with proper disclaimers, which we did. And then also repeated in marketing letters. Also, the savings figure in the software savings analysis for each year was thoroughly reviewed, in addition to all our phone scripts, marketing materials, everything. So that's just the foundation. In 2010, we were scrutinized for 2 years, and since that point, we had complied to that agreement that was made with Richard Cordray as Ohio AG. Part 1, the starting point. The starting point involves two deputy district attorneys in 2 small counties in California near San Francisco. In 2004, there was a proposition on the ballot revising the California Consumer Protection Statutes in order to stop frivolous lawsuits. Unfortunately, this revision actually ended up creating an atmosphere for lawsuits because of the lure of 100% of the civil penalties that these district attorneys are able to get out of a company, whether it's legitimate or not, is set aside for the consumer protection section of the county DA's office. This has been referred to as the county bounty in a book about the consumer laws in California. It goes to the DA's office to pay their salaries. John Hubanks is the head of the consumer section in Monterey County in California. Andres Perez is the head of the consumer section in Marin County. These are the 2 people whose names come up over and over again in the events that are going to be described. February 2013, fabricated complaints. These 2 deputy DAs explained to NBA and to several courts that the company had come to their attention because of a consumer complaint in Monterey County in the spring of 2013. So this was after we settled everything with Richard Cordray with the agreed order of voluntary compliance, February of 2010. So we were fully compliant with our AG in our state. We were also licensed in over 40 states, complying with everything they required. And if there was ever an issue that came up, we 100% resolved anything that ever came up, which was very rare. We had on-site audits that were done by different state agencies around the country, always achieving a very successful audit with these states, where there was one in particular that was so impressed with how our operations were run that they were forming their department in their state for regulating this industry after nationwide biweekly administration, because they found it to be ran so efficiently, successfully, compliantly, So let's continue on. So these 2 DAs said that there were some complaints in Monterey County in the spring of 2013, but this was not the truth, however, that we later learned. So the very first thing that happened that I'll explain was in fact a lie. So that's the foundation of how all this began. The truth was discovered over time, and we now know that these events began because a letter just happened to be received by someone, Eric Hickok, whose wife, Emily Hickok, was a deputy DA in the consumer section of the Monterey County District Attorney's Office. The letter was a direct mail marketing letter from Nationwide Biweekly Administration, educating people about a biweekly mortgage interest savings program and asking interested persons to call the company in Ohio. The letter made its way into the consumer section. There was no actual consumer complaint to the DA's consumer section in Monterey County about NBA. We know this because NBA requested that the DAs produce all consumer complaints. And there is nothing from this person, and in fact, no actual consumer complaints to this DA consumer section office in Monterey County. Nevertheless, the consumer section claimed a consumer complaint, started its investigation when telling its story to courts later on in these events. All of this was unknown to NBA until much later, when NBA put facts together. Only much later did NBA come to understand that this consumer complaint claimed to be legitimate and to have started a legitimate investigation was in fact totally fabricated. There was no real complaint to the DA's office. Why is this so important? We can only tell you that we believe that the DA's statements about the consumer complaint, and when we learned this was a false statement, we were absolutely shocked. As a result, we began to question whether other things were not as they were that were claimed by the DAs in the process. And our questions proved to be valid as a result of this story unfolded. Much later, NBA was provided with other complaints, allegations from consumers in response to discovery requests. It turned out that one alleged consumer complaint in 2008 was from a DA office employee, Vicky Long, the DA video unit. Another alleged consumer complaint in 2010 was from another DA office employee, David Ball, DA Consumer Services Coordinator. The DAs redacted the names of these persons. Why? Because they were employees of the office. But NBA was unable to determine this information NBA was able to determine this information through reverse engineering certain numerical codes that were on the direct mail letters to obtain the name of the person to whom the letter was mailed, because they had provided us the actual letters along with the alleged complaint, and we were able to reverse engineer and find out who these people truly were that they redacted. Then upon further research, it was learned that none of these people were customers, nor had they called into NBA identifying themselves. The DAs failed to disclose that these alleged consumer complaints were made by persons affiliated with the DA office employees. While employees certainly have their own opinions about things, this affiliation, nevertheless, should have been disclosed. NBA should not have been required to figure it out on its own. What was it about this investigation that made them want to cover up its real beginning and pretend that it was unaffiliated? It was an unaffiliated consumer complaints? Well, before I answer that, there's an update in 2017. I'm going to jump ahead just for a second. The DAs are called out by the Ninth Circuit. John Hubanks, the DA from Monterey County, who was really what I would say is the kingpin, along with Andy Perez, of everything, of all the destruction that would soon to come, and then bringing in the CFPB to team up against me and my company. John Hubanks, the DA from Monterey County, was called out by name for misrepresenting the beginning of his investigation as being a consumer complaint, when really it was a manufacturer complaint by the spouse of one of his fellow attorneys in the consumer section. The Ninth Circuit chastised him and told him never to do such a thing again. And yet these were the partners CFPB was helping to get their own civil penalties, again, for their office. 100% would go to them, to their office, by joining them in the prosecution of NBA. And as I share this information, please understand, I am sharing my opinion, my thoughts, what I feel and believe about the situation. So again, please understand, I'm trying to give as much fact as possible, but also at the same time, I'm giving my opinion in certain situations. So I want to be completely forthcoming and upfront about everything. June 2013. So we were at, February 2013 when the fabricated complaints were made known to NBA. So now we're June, a couple months later in 2013. The DA office makes a secret call to NBA. In June 2013, an investigator from the DA's office in Monterey called NBA in June 2013 pretending to be Eric Hickok, who had received an NBA letter. He asked some questions about the program. We learned about this call only by coincidence when the DAs turned over a copy of the NBA letter. The letter itself had numbers which allowed NBA to identify the person to whom the letter was addressed and then to access any recorded calls from that person. See, one thing about our company is we record almost every one of our phone calls for consumer protection and also for training purposes to make sure that our employees are following all rules, all regulations to make sure that we are always compliant with the Ohio AG agreed order of voluntary compliance. And so that's why these calls are recorded. In this case, however, the caller was a secret investigator from the Monterey County DA office pretending to be a customer by the name of Eric Hickok. So that in itself is fraudulent. One of the items discussed at 2 points in the call was whether NBA was affiliated with his specific lender, Provident Bank. The investigator totally understood that NBA was not affiliated with the lender, and he repeated this fact. He confirmed from his earlier conversation at the end of the call, this investigator on the phone with one of NBA's employees, his exact words were, "All right, you guys are in no way affiliated with Provident though." So he said it with his own words that he fully understood from the conversation from the NBA employee that we were not affiliated, and he even reiterated it back to our employee. In sum, NBA explained to the investigator that there was no lender affiliation. And we also later learned that the DAs had the envelope in which the letter was mailed, which stated on the outside to the right of the address window that Nationwide Biweekly Administration is not affiliated with the lender. So it wasn't just at the bottom of the letter, which is typically where you'll see almost every disclaimer, whether it's from a financial institution or any company. We put a disclaimer on the outside of the envelope before even opening the envelope. They would see it in their mail, addressed to them, referencing the lender, and saying right to the right, we are not, Nationwide Biweekly is not affiliated with the lender. That was a requirement of the Ohio AG with Richard Cordray that we complied with, and we had no problem doing that. And we had done it ever since. So late July 2013, DEA investigation of NBA. NBA knew nothing about these events or the two deputy DAs until late July 2013 when a letter was sent to Ohio from Monterey County Deputy DA John Hubanks saying that he had a joint investigation going with NBA with Marin County Deputy DA Andy Perez, who I mentioned both of them from the very beginning. However, when they came after NBA, they weren't aware of many items that NBA's history and came after NBA for things that had already been worked out many years ago with the Ohio Attorney General's office when Richard Cordray was Attorney General. Okay, so they're already coming after us with lies of their own. Okay, so number one, the thing that came after us was the lender name use. Referencing the lender's name, another survey that was done of consumers, when they called in, they were asked, does it help to have your lender's name as a reference that our service works along with, or you're able to utilize our service with that loan you have with your lender? And I believe it was over 80% of the customers said, yes, that helps me to understand, to make that connection to that point. And so we asked, well, if it wasn't there, would you have made that connection? And a majority of the people surveyed said, no, I probably wouldn't have made the connection and just thrown the letter away. So this program is saving the consumer interest, paying off their loan a lot faster with just an automated program. They don't have to have it. It's their choice. But those who are on it would be 100% successful because as long as the automation continues, they're going to make that 13th payment. And a lot of people would even have their debits increased a little bit or rounded off, and they would achieve even greater savings and more funds going towards the principal of their loan much faster. So I don't mean to jump off. I'm just kind of giving some little information about the purpose of NBA along with what's going on here. So the lender name use, they came after us. And so first of all, the DAs complained about NBA's direct mail marketing letter and it referenced to the name of the mortgage lender. After finally learning the truth, it is rather amazing that these deputy DAs said in their letter that consumer complaints led them to initiate their investigation. We already know that was a lie, when we now know that there were only fabricated complaints from employees. And they omitted any disclosure in their letter that they had the envelope with its lender non-affiliation disclaimer. They did not state that they had that. And that their own investigator had called the company and had completely understood that NBA was not affiliated with the lender. When that call, the gentleman made the call from their offices pretending to be a consumer, they did not acknowledge the fact that that investigator who called trying to get facts to see what we say, that in fact understood and heard from the employee that we're not affiliated. They totally disregarded that. All in all, the letter from the Deputy DA Hubanks contained statements that were simply deceptive and not true, as NBA later learned, and omitted statements that should have been disclosed. More importantly, however, these deputy DAs did not take into consideration that in 2010, the Ohio Attorney General entered into an agreed order setting forth all the requirements for NBA going forward, which was approved and agreed by then Ohio Attorney General Richard Cordray. Now keep in mind, when the CFPB comes into the picture, who is the director of the CFPB at that time in 2014 or 15? Was Richard Cordray. They acknowledge that in Section 2J, it specifically states what disclaimer regarding the reference to the lender's name must go on the outside of the envelope as well in the marketing letter. And this NBA did in fact do regarding the use of the lender's name in California. Typically, a disclaimer is also needed in that state, but there is an exception for comparison advertisements. NBA's later is a comparison of the lender's monthly payment schedule and NBA's biweekly program payment schedule. But NBA chose to go above and beyond what was required in California law, and still put the disclaimer on its letters and envelopes because of our agreement with the Ohio Attorney General Richard Cordray in order to honor that agreement. Even though in California, because of the comparison advertisement exemption, we would not have needed to, we still did it anyways. Number two, licensing tactic. This is another tactic that the DAs used, came after us for. The DAs complained about NBA not having a license that they claimed was applicable. However, they pretended that NBA didn't have any license, and they did not acknowledge anywhere in the letter information about NBA's actual California license that we did have for many years. NBA had been licensed back in 2004 by the California Department of Real Estate. This license was public record, and the deputy DAs had no excuse for not knowing NBA's license information and for not putting it into their letter. NBA had obtained this type of license for its biweekly program in 2004 after discussions with the California Real Estate Department, which had licensed several other biweekly companies, and stated that this is the license that we are to get. Had they checked at the time with the DAs when they wrote this letter, they would have learned that NBA's license was in good status, having been renewed as applicable since 2004. But the deputy DAs just dug in and doubled down to claim that NBA should have gotten a different license from a different agency. It's a prorater license from the Department of Business Oversight, the DBO. Of course, NBA would have gotten whatever license was required back in 2004 when it was first licensed. But why would the DAs care about something that these two agencies, they needed to work it out between their agencies? We did what we were told to do in 2004. We later uncovered that this was a chess move that's happened before when other small county DA offices use the same "you need this different license and you don't have it" argument or tactic. Deputy DA Hubanks actually put us onto this prior case, put this same strategy on a prior case by answering a question as to whether there was any precedent for their claim about this other license. Deputy DA Hubanks responded that this same claim about the prorater license involved the company freedom debt relief. NBA later learned, however, from public records in that lawsuit that after the payment of civil penalties was already made to Mr. Hubanks' office, suddenly the license was no longer required and freedom debt relief was never licensed as a prorater. Only after the civil penalties were paid was the license claim dropped. Is this the go-to license when the DAs want fine money? After all, it was only the DAs that created this conflict with two different agencies in California. There was no license questions raised by the real estate department, which had informed NBA that theirs was the license we needed. Nor did the Department of Business Oversight contact NBA saying that we needed the prorater license. This was just a strategic move by the deputy DAs to come after NBA for fine money. Next section, prorater licensing scam. What emerged much later is that the prorater license had always been for consumers in financial trouble to sign up for a company that would contact their creditors and do a debt management, spread out reduced payments amongst creditors. We don't do that. We just take their current mortgage that's not in trouble, take their monthly, debit every 2 weeks, and then remit the payments to their lender on their behalf. That one creditor, that lender for that loan. But the prorater license is for debt management, spreading out reduced payments amongst several creditors, those who are in financial trouble, or a debt settlement to satisfy the debt in full by a negotiated lesser amount agreed by the creditor. This description of the license goes back decades to the 1950s. Of course, these descriptions of the license talking about people who couldn't pay their debts and needed help from a prorater company did not describe a biweekly interest savings company such as Nationwide Biweekly. Customers of NBA had just recently been approved for a new mortgage loan, so obviously they did not have financial difficulties and could afford to pay all their debts because these were brand new mortgages. That's the kind of customers that would sign up for our biweekly program. The prorater license made no sense. Apparently, the agency and the DAs knew this made no sense because suddenly later, the website description of the prorater license changed from the decades-old descriptions of consumers in financial trouble seeking to negotiate a better deal to a generic definition about transmitting money that could fit anyone. That happened right in the middle of these allegations against Nationwide Biweekly. Just suddenly, out of the blue, it got changed on their website. The agency still has a 2014 brochure on their website that says a general prorater contracts with delinquent debtors and mediates with creditors to settle debts on behalf of the debtor, as well as a 1999 statement that says that under the check sellers, bill payers, and prorators law, the Commissioner of Corporations, regulates the licensing and regulation of prorators, persons who either contract with delinquent debtors and intercede with creditors to settle debts, so forth. So how is this change explained that they made on their website? And we have this documentation in our records. If it's a legitimate change, why was this done in secret and never explained in the agency rules or notices? When was this done? Who made this change, and did that person have authority to change the law? Was this just a coincidence that this change was made after this targeting of NBA began and NBA fought back by pointing out these descriptions on the agency's very own website? Some of this is just common sense. It doesn't take much to really follow exactly what's happening here. Again, the update of 2017, jumping ahead for a second, the DA is being called out by the Ninth Circuit. The CFPB, partnering in the prosecution of NBA, had one claim rejected on constitutional grounds, and one of the DAs called out for bad behavior by the Ninth Circuit, as I mentioned earlier. The DAs were not were not meritorious partners. Given the impact of the civil penalties to their consumer section budget, it is no surprise that the Ninth Circuit rejected this claim on the grounds that California cannot require an Ohio company to become a California company under the Interstate Commerce Clause of the Constitution. The pro-rata license tactic by the DAs was now rejected by the Ninth Circuit. A quick update, even in 2018, the California agency has now dropped its position that a pro-rata license was required. This happened right after the case reached the California Supreme Court, and the agency reached an agreement with NBA to drop any claim about a pro-rata license and dropped out of all litigation against NBA. So now the DAs are standing alone without the DBO and the pro-rata license scam.
But now without the DBO, they have to team up with another agency. So spring of 2014, the DAs demand money and they now collaborate with the Bureau of Real Estate, where we have our actual license since 2004. About 6 months after sending the July 2013 letter, in the spring of 2014, the DAs told NBA's attorneys that they would have to get a 7-figure in fines. That's what this was all about. It was about money. As discussed above, 100% of the fine money goes to the consumer section at the Monterey and Marin County DA's offices, paying their consumer section operating expenses and salaries. And the DAs made another chess move in the spring of 2014. They reached out to the agency that we had been licensed with since 2004, the Bureau, formerly Department of Real Estate, and convinced the Real Estate Bureau to do an audit of NBA. Wasn't necessary, nothing tipped them off to do it, but now John Hubanks is trying to create a problem. So he convinces them to do an audit of NBA to try to uncover anything they could to use against us. And suddenly the Bureau of Real Estate did in fact commence an office audit beginning in June of 2014. Deputy DA Hubanks followed up through email, continually urging the Bureau of Real Estate on. At the time, NBA knew nothing about these backdoor contacts by the DAs and John Hubanks. Now, the summer of 2014, we're able to convince the DAs to have a settlement meeting. Finally, the DAs agreed to hold a settlement meeting in the late summer of 2014, but they created an agenda that, as its first item, had the choice between criminal versus civil. So no longer were they threatening about money. Now they're trying to intimidate that this could become a criminal matter. At this point, NBA seriously became worried about their true intentions. Only the attorneys attended the settlement conference in light of this improper agenda item. It's no wonder that this meeting did not produce any results or even anything constructive. But you must understand that NBA was grasping at any way to resolve this matter. In fact, about a month before this settlement meeting, just a personal note, remember I had a dream and I woke up, and in the dream I was in a hotel room and police officers came banging on the door to arrest me. And I, for some reason, knowing the nature and the fruit of John Hubanks and Andy Perez and their tactics, that would have actually happened, just to intimidate and scare me. And so that's why I did not attend. So now September 2014, so there was nothing constructive whatsoever with the meeting. Nothing was accomplished at all. So it's just September of 2014, applying for additional licenses with DBO. Remember, they're still demanding the prorater license. We know what happened in 2017. I gave you a little update earlier, but we're still in 2014 right now. NBA continued to try to resolve the matter. At this point, NBA really gave in and went ahead to try to obtain this prorater license. despite knowing that it was not applicable. In September of 2014, NBA took 2 actions designed to work cooperatively to resolve this matter. First, NBA applied to the same department that the DAs brought in, the DBO, Department of Business Oversight, for the license that they claimed we should have, a prorater license. Admittedly, this would have been a second license in addition to the Bureau of Real Estate license we had since 2004. Second, at the same time, NBA also applied for the same type of license that the Ohio Department of Financial Institutions has said was the appropriate license for NBA to have, which is a money transmitter license. NBA had a money transmitter license in most all other states, about 40 licenses in all. And California had recently adopted a money transmitter license in 2010 that was not in existence in 2004, when NBA obtained its original California real estate license. The thought was that this matter could be resolved through the money transmitter license, which was the exact license that we had throughout the country, throughout the nation. This would be a great resolution that would involve the Department of Business Oversight, which is the agency regulating both the money transmitter license and the prorater license, and would also coincide with all other states. Third, 2 applications were now pending before the California State Agency, the DBO. NBA made a request that the DBO make a determination as to which license was applicable, money transmitter or was it prorater. Initially, the department indicated through the deputy commissioner that the money transmitter division that NBA's business model fit into the California money transmitter license category. But here's where it gets interesting. The attorney who had been brought in, with the 2 deputy DAs and who was employed by the DBO, Robert Lux, blocked the money transmitter license application from being processed. Moreover, the department didn't process the prorater license application either. Nor did the department provide an official determination of which license was applicable. No matter which way NBA went, whether with the prorater license application or the money transmitter license application, the California Department of Business Oversight suddenly refused to do its job, to make a determination of which license was applicable to NBA and to process at least one of these 2 license applications. I wonder why. Now, October of 2014, lawsuits now begin with the DAs, and at this point is where the DAs bring in the CFPB. NBA was genuinely trying to work through the issues and to be cooperative. After the first settlement meeting in Monterey, California, NBA asked for a second meeting to occur a few weeks later to discuss some items that had not been discussed previously. NBA believed this discussion could lead to a resolution. The DAs refused this request for a second meeting to discuss settlement. Declining a second meeting was perceived to be a stonewall put up by the DAs and to be very unreasonable. But when they declined the second meeting around the same time that NBA got nowhere on the 2 license applications, the picture became alarmingly clear. When they refused the second settlement meeting, they wrote something that said it all to NBA. On October 1st, 2014, Deputy DA John Hubanks, after consulting with Andy Perez and the Department of Business Oversight, Robert Lux, said, "Our offices are done with the games." I'm sorry, whose games? "We will not be extending the tolling agreement. Please advise if you are still authorized to accept service of process on behalf of Mr. Lipsky and Nationwide," which was for a lawsuit. NBA was just flabbergasted that it would falsely be accused of playing games despite all of the above things it had done to resolve this matter. Who is playing the games? This message was understood to say that the DAs were filing an immediate lawsuit against NBA on behalf of the state of California. Now, NBA was forced to look at its options because it was getting blocked on the settlement talks and blocked on the license applications. Over the past weeks, NBA was starting to realize that it may need to seek relief in federal court from this behavior by two government attorneys with positions within the California state government that allowed them to file a devastating lawsuit against NBA. That all started with lies. So with this last statement about service of process, and with all other alternatives being exhausted, NBA worked until 3 a.m. in the morning in order to file a federal court lawsuit the next day on October 2nd, 2014. The need to seek a preliminary injunction, we had a great need to seek a preliminary injunction and declaratory relief, and it was urgent. At the same time that the DAs were threatening criminal versus civil, at what turned out to be the one and only settlement meeting, they were also working through the back door to move the chess pieces again in order to get a more powerful player. And this is why the CFPB was called in by the DAs. I'm going to end this with part 1, and I'm going to do a part 2 to continue on now with the CFPB becoming involved.